Well, welcome to another CIPL seminar talk. I'm not sure if this is the last one of this academic year. Perhaps we have one or two more. Yeah. So look at the website if you're interested, especially if you want relief from exams and something more light to listen to. Anyway, so I'm very much honored and have the great pleasure to introduce briefly Graeme Dinwoodie, who doesn't really need an introduction in IP law. He's been the Oxford Professor of IP law for about 10 years, I guess.
Yeah, almost 10.
And you've been in Chicago before, and you're back in Chicago, and you had various posts around the world, and you've been teaching all over the place, and doing lots of really interesting research. I think I started looking at your stuff more than 20 years ago when I wrote my PhD. More than 20 years ago on databases, because I also did some stuff on that. But anyway, so Graeme is going to speak about non-traditional marks in Europe, conceptual lessons from their potential demise. So the interesting point is that in my revision lectures, I see some of the students here from the tripos, and it's also good that the examiners are in this room. I mentioned
You're going to disclose that tonight?
There's so many people in the room. So I actually said that the non-traditional marks under the new directive and regulation have been sort of broadened in the sense that they're mentioned particularly, and then the representation requirement is amended to an effect which makes it perhaps more easily to get protection for them. But as we will learn now, perhaps that all is not true. At least it might be sort of counter sort of balanced by court decisions which have given less protection to those kind of non-traditional marks. So I leave it to Graeme to discuss all of that, and thanks for coming.
Good, pleasure, Henning. Thanks for the introduction. Good to see everybody. Some new faces, some old faces. I'm going to try and do three things. And I've got a lot of slides on the handouts, and I'm happy for people to get digital copies. There's way more slides on there than I could possibly talk through, even at the speed at which I normally talk. So you can get them for your reference. But I want to just briefly go through some of the case law, because I may have a different take on some of the case law, which is therefore a different premise for the paper, but whether there is a demise. So I want to cover some of that. As I do that, I will critique some of that case law on its own terms, by which I mean they're just simply internally wrong, either in interpretation of the statute or the directive, or inconsistent with the purposes of trademark law. In particular, what I want to spend a bit of time criticizing is the Nestle Cadbury decision on the four-finger Kit Kat from the English Court of Appeal, which I think is very wrong. And I want to spend most time on that because it's been copied, it's been followed in other countries around the world, including Singapore, in a pretty influential decision by a good Singapore IP judge. So if I get onto Hauk and the other ones, which I also think have problems, a little bit, Nestle is the one I want to spend most time on. And I want to spend a little bit of time, and therefore, Henning, if I go on too long, stop me. The last few slides, just to suggest, and this is much more speculative at this stage in the paper, some of the broader lessons for European trademark and unfair competition law from this case law. And I guess if I can sort of get to that stuff in the bottom line of that at the moment, because that's really what I want to take the paper eventually, it is to mimic something I wrote about American trademark law almost 20 odd years ago, which is the last thing we need is more doctrine, is that European trademark law is becoming tremendously complex, and the way that the British courts and the Court of Justice are approaching it is as though it's some sort of mechanical flowchart through which they have to navigate to get to an answer at the end. And I think one of the things that has to happen is to prune back and pare back the complexity in a couple of ways. The most significant way is to have a purposive approach to the way you interpret the different features, doctrinal features of European trademark law. But secondly, to understand that the different features don't operate in isolation from each other. That is to say, when you make a validity determination, there has to be some regard to the questions of scope and questions of defenses that exist. And likewise, when you think about scope, you should have some regard to how close you came on the distinctiveness question. And there's about 3 or 4 different iterations of that dynamic. And the Court of Justice on the whole takes a very scientific, they would call, approach to where they treat these as all separate questions. And I want to suggest they're actually interconnected, and Nestle shows that, I think, very, very well. So that's where I want to get. On recent case law background, I'm going to focus mostly on acquired distinctiveness and functionality, because that's the big cases where the British courts have, I think, screwed up. But I'm going to start with a couple of other areas because they affect the background of product design and non-traditional marks more generally. So, as you know, this is actually for Monroe's opinion in the other chocolate case, the purple case, where Cadbury's wanted the color purple for trademarks. 3 requirements coming out of the definition. This was under the old law, of course. It must be a sign, must be capable of graphic representation, and it must be distinctive. And to just give a quick sort of recap of the other adjacent doctrines that are relevant here. In Seekman, of course, the Court of Justice interpreted graphic representation as requiring that the form of graphic representation satisfy those 7 criteria, unimaginably called the Seekman criteria, for whether or not something is properly graphically represented. And the goal there was to ensure that both the office and competitors knew exactly what it was that there were rights existing in. All right, and that was meant to be both pro-competitive, pro-efficiency, and represented a question of fairness for competitors in the Seekman case. Now, as this may be a little bit what Henning has adverted to, some people think that in fact that's all gone away with the 2015 reform, so the regulation already implementing it and the directive being implemented in different countries. My argument would be that nothing has changed, and the reason nothing has changed is because what the recital does is simply state that when the office is now implement, the administrative authority they're now given to work out when a sign is satisfying the different definitions of what is a sign. They take into account these criteria, and the criteria are exactly the same Seekman criteria. So what they've essentially done is move what was a provision that was in the statute into something that is now administratively implemented, but a court will have to review that at some stage according to exactly the same criteria that Seekman articulated. So I don't think it's made any difference, except that it's given offices a little bit more flexibility to work with new technological forms of deposit in order to represent goods. So Seekman's criteria still exist to curtail the way we would define what is a registrable mark, and moreover, even outside of the graphic representation requirement, the Dyson case, which is the transparent bin from vacuum cleaner, gave us another form of constraint through its interpretation of the term sign. And a couple of points I want to make about this case, because it's relevant to some of the conceptual points at the end, is that the questions from the British court that went up to the Court of Justice, and indeed that the Advocate General focused on to some extent, though not entirely, were different questions than the grounds on which the court answers. The British court actually asked questions about whether or not the mark was actually had lacked distinctiveness, and when you would assess potential acquired distinctiveness. And Advocate General went into questions of whether it was functional, decided all these questions that were regarded as the more dominant parts of the absolute grounds for exclusion. But in fact, as you probably know, the court came back and said, well, actually, it's not a sign. It's not a sign because it's too abstract. And why does that matter? Well, why it matters because some of the grounds the British courts had raised were ones that could have been overcome by proof of secondary meaning. But once you said it's not a sign or it's not capable of graphic representation, then in fact, consumer association, which trademark law should care about, is thrown out the window. It said it's entirely irrelevant, cannot be registered as a mark. So the ground on which they went forward actually turns out to be very, very significant. And if you look at the reason that they came up for why they had to deny registration to the concept of transparent bin, was that it was abusive and anti-competitive because it claimed a multitude of signs. Right? And I want to come back to that in a second when we look at the way the British courts have read that. But the idea that the one registration would cover a multitude of signs was too fuzzy at the edges, such that competitors would suffer a competitive disadvantage, and therefore we shouldn't allow that. Now, the British courts ran with that, and I think have very aggressively interpreted the requirement that a sign must only reflect one potential mark. And so the two cases that are most notable are the purple case, one of the other Nestle Cadbury fights, and the Scrabble case. I think the Scrabble case is probably rightly decided, but I think Nestle is wrongly decided. I think all the chocolate cases are wrongly decided for some reason or other. In the event, in this case, you know, the important part of the description was they properly identified under the rules that Libertel had said you should identify for graphic representation purposes the color, so they used the Pantone color, but they put in the description that had to be applied to the whole visible surface or the predominant color applied to the whole visible surface. And the problem with that is the description and the use of the term predominant encompasses a variety of different possible marks. There's lots of different types of marks that would actually satisfy the idea that, or the concept that something was the predominant color applied to the visible surface. And so consistent with Dyson, says that Court of Appeal, that therefore is not a sign, it's a concept, and therefore it can't be protected. Now, if you actually look at what they said in purple, they weren't as clear about the line between sign and graphic representation. So graphic representation was about certainty, sign was about pretending abuse by claiming multiple marks. If you actually look at the holding in purple, they don't come down on one or the other, so it doesn't constitute a sign that is graphically represented. They sort of straddled both of those two particular grounds, and if you look at the justifications for that holding, you'll see that they mention both of the justifications that you can extract from Dyson and that you can extract from Stickman. So interestingly, they weren't all that fussy about which pigeonhole they were putting into it. They said it seemed to fail, whatever it was, it didn't satisfy the definition of what is a mark. And that, I'll come back to the criticism I have of that in a minute. The Scrabble case, which was handed down, argued together and handed down on the same day as the purple case, it's likewise said the title mark was neither a sign nor satisfy the graphic representation. And the particular argument that in that case that I want to highlight as indicative of the formalism that the British courts have read into the Court of Justice's case law is rejecting what Lord Justice Murray called the Paella approach to Article 2 of the directive, which is the definition. So James Mellor, who was arguing for the plaintiff, or the applicant, argued that when you're working out whether something's a mark, you look at a bit of sign, you look at graphic representation, you look at distinctiveness, and you use those essentially as a multi-factor test as to whether there's something out there that's sufficient to give notice to competitors and to satisfy the purposes behind the definition of a mark. All right? And he called that paella. You put them all in the dish, you stir them around. Does it look like it's a dish? Does it look like it's a mark? And Mummery said, I reject the paella approach. It has to satisfy every one of these separately. Whereas the argument was, look, everyone knows it's Cadbury's and it's purple. And maybe the word predominant is not absolutely clear, but given that we all operate in the real world, everyone knows exactly what that mark is. All right, that was the argument that was rejected, the very formalistic approach from the British courts. Now, so here the criticism I have all that stuff is something that's actually drawn a little bit from American law, which is how do you actually, if the competitor, get notice of a mark? Now, if it's a word mark that's inherently distinctive, you get notice of that mark from the register. But trademarks that are non-traditional marks cannot essentially, effectively, be registered absent secondary meaning acquired distinctiveness. They're always used. So competitors actually get notice of the mark from the way it's used in the marketplace. Because that's effectively going to be, at the end of the day, what defines your mark. So I think there's a little bit of an undue formalism in the way that the British courts have been really strict about these different requirements. I think Mellor's paella argument actually a lot of merit to it. Now, you may say, look, that's too sloppy. You're giving someone a bit of property. Competitors really need to know what the bit of property is. And I would say, well, that's true if that mattered. But actually, when you're talking about what a trademark is, the bit of property you get is not simply a function of what's on the register. It's a function of scope. So just to give you an example, let's assume, that's my deck there's on the Titanic point, which is we're getting very fussy about the way we go down and hit the iceberg, is if Cadbury's had said, It's 50% exactly. You can take a sort of 3D ruler and you can work out it's 50% of this packaging is covered with purple. And then you said to a competitor, all right, what is it you can do? Does that mean you can use 49%? No, that would be determined by whether or not a consumer would be confused by 49 coverage being similar to 51% coverage. 35? Ooh, now we're getting close, right? But it's a fuzzy line, right? It's not defined. The scope of trademarks are not defined with the degree of precision that they want to sort of impose on the registry requirements. Now, say if you had a different approach to scope, and we'll get to this when I get to the Louboutin case. If you had a question of scope that said you only get, for example, the use of the exact mark on the same goods, that's your scope of protection. If we had rules that actually sort of implemented that, and the only one that gets close is really double identity, then in fact that would really matter a lot, right? If in fact you're relying on scope as the principal determinant of the metes and bounds, I think it's obsessing on the wrong thing. And moreover, in terms of the multitude of marks, you may remember the Specsavers case, right? So Specsavers, effectively, Specsavers got many marks. They got every conceivable color with one registration. That's a multiple uses of marks, right? Why are we not so worried about that, the way we are with non-traditional marks? So I think both in its own terms and in terms of what matters in trademark law, the purple decision was probably wrong, and particularly, I find it odd, is that I actually think if they said the color Pantone code applied to the packaging, they would have gotten the registration. The irony is that by putting in what was probably meant to be a limitation, right, which would shrink their trademark registration, but think about it in patent terms, would shrink the scope of their claim, they ended up invalidating, right? There's some irony to that, and you don't want to encourage people to put in broad claims. Other point which we'll come back to, which is, all right, does that mean that Nestle can use purple? No, it doesn't, because they'd be sued for passing off, all right? And if you've just moved all your competitive battles from registered trademark to passing off, if you think that enhances certainty, you haven't read enough passing off cases, all right? Because now the notice is, what is the goodwill in the market, right? And it's how it's used on packaging, right? So you've gained absolutely nothing in terms of certainty by this whole endeavor. So that's sort of just a background on some of the other two doctrines before we get into the two key ones I want to talk about on distinctiveness and functionality. So distinctiveness, again, just 2 slides on sort of simple background doctrine. But in trademark, for non-traditional marks, effectively, in Europe, we require distinctiveness, right? Not nominally. So nominally, it's the same distinctiveness test for non-traditional marks as other types of marks, but the court has made pretty clear that in practice, consumers will not regard non-traditional marks as so identifiers, and particularly for shapes, we're looking for significant departure from the normal norms in the industry, from the Henkel case, and effectively that means that you require acquired distinctiveness, which actually is the rule of law in the United States. So it's sort of effectively the same, but through a different construction. This is particularly problematic, we'll come back to it, when you combine that rule, that for inherent distinctiveness you would look for a significant departure from the norm, with the rule on substantial value that comes out of Hoke, which says that if the sign is tremendously novel, the shape is tremendously novel in the industry, it probably regarded as aesthetically functional because it's adding design or iconic value. So you end up with what I call the Goldilocks problem, right, which is that it can't be too hot or too cold. It's just going to be just right in the middle if it actually wants to have distinctiveness. But what it effectively does here is it pushes all the debate on distinctiveness in non-traditional marks into acquired distinctiveness, and that's really what I want to spend most of the time chatting. So all that's really more for background for when we get back to the discussion about some of the conceptual questions. So you probably know this case. I'm sure, Lionel, you probably lectured on this stuff, right? I assume that you're obsessed with chocolate, so yeah. Lionel is going to teach a course on chocolate and trademark at some stage. I know that from his slides. So you may remember, so the register actually has holdings on both distinctiveness and functionality. I'm missing most of the one on the distinctiveness, and I'll mention the functionality holdings later, but the distinctiveness one is the crucial one. And essentially the question was, have consumers come to associate that shape of the Kit Kat with one particular producer, Nestle, right, who make the Kit Kat. And the registrar had pretty good, what would have probably regarded as pretty good survey evidence that when people saw a picture of the Kit Kat, they at least associated and recognized that as Kit Kat, right? And he discounted that evidence on the basis that he said that consumers didn't rely on that shape to identify the Kit Kat when they purchased the Kit Kat. And the reason they didn't is because Kit Kats, as you may know, come wrapped in opaque wrapping, so you don't see the shape through the wrapping. And they have the rather famous word marks, Kit Kat in red and white all over it. And even when you take it off, in fact, the word Kit Kat is embossed in the top of the chocolate. And so the court said, the registrar said, I don't see any evidence that in fact people rely on that. And the test for secondary meaning, he said, was that consumers relied on the shape in order to identify the origin. He has a sort of, I think, a reliance light caveat to it, which is that the consumers use the shape post-purchase to check they've chosen the product from their intended source. That might have been enough. I don't know where he got that from, other than some practices involving the wine industry, which comes up in some of the cases. But essentially, he said the test is reliance, not mere recognition. All right. Now, I'm going to try and show you that they're all wrong on that. So Richard Arnold gets the case, and he sends a question which is, in one sense, beautifully clear, and in one sense, terribly confusing to the Court of Justice. So, picking up a little bit on the distinction the registrar drew, he said, is the test that the relevant proportion, so significant proportion, recognizes the mark and associates it, which is what the language of the survey was, or must you prove that they relied on it? And the registrar, of course, said they weren't relying on it, they were using the word mark and the wrapping and all that kind of stuff. That was very clear, quite binary. I'll suggest in a minute it was not a useful binary, but it's at least clear, a binary. Where he sort of messes it up is parenthetical. So he puts in a parenthetical as opposed to any other trademarks which may also be present. And so what he's done is conflated two different, far distinct in his issues. This is what you see referred to as the limping mark issue in the parenthesis, which is to say, to what extent have you relied on one mark that's really not a mark unless it's used with something else that helps to support it, right? And the phrase comes from Robin Jacob in the Phillips case, all right? And I think this heavily drives the debate. And if you look at the references by the Court of Justice to have a Kit Kat, another Kit Kat case, and the Colosseum case, you see this is actually what they're concerned with, most of the case, right? But it's only in a parenthetical in Arnold's question. He suggested the answer was they must rely, and the reason he did that is he decided that 10 years before as an appointed person in the Five case, that was the test, so he obviously thought that's the test. I want to highlight one thing he said, however, because it comes back to be relevant in the Court of Appeal, is he says that the current position, notwithstanding his requiring reliance, the current position in English courts was that it wasn't essential that the applicant had explicitly promoted the sign in question as a trademark. Right? The question is whether consumers associate it. It's not whether the mark owner actually has taken conscious efforts to promote it in that particular case. That is not required in order for something to be a mark. All right? So the Court of Justice comes back, and if you read Arnold's opinion, it's actually a wonderful opinion to read if you want to engage in a critique of the role of language in a multilingual institution such as the European Union, where he talks about the fact that the questions were translated in a way he thinks that messed up the binary question that he had presented. And he started to work out whether the Belgian Advocate General was reading it in French or German. I mean, it's all sort of hypothesis, but it's sort of interesting and raises, I think, genuinely interesting questions about the use of language in multilingual systems. But they reformulated the question either because of the translation error, though I would argue not. If you read the whole opinion, you see that they clearly do restate his question in the terms of his question early on, and then they change it. And they reformulate it as a question of whether or not an applicant has perceived the goods as coming from a single person as opposed to a different source, or whether it's sufficient to recognize the mark and associate. So if you think about it, he'd asked rely and recognize and associate. They've really replaced rely with perceive. right? Now that perceived language is just boilerplate from all their other prior decisions on secondary meaning, right? Whether they were actually trying to change the question or give you a synonym for reliance, I think it's open to some debate, because it just looks to be boilerplate. But they reformulated it, and they reformulated it when they picked it. They restated the reformulated boilerplate language, requiring the question is whether you perceive the mark as coming from the goods and services, as opposed to any other mark which might also be present. So this part is answering the parenthetical. This is sort of saying, look, the key here is when you look at these multiple composite marks, is the shape acting as associative identifier as opposed to the other potential marks that KitKat had registered, right? So they were answering a little bit of the have a break, have a KitKat question and the Colosseum question at the same time as they are trying to come up with the standard. But to be fair to Mr. Justice Arnold, it was a hard to fathom opinion because there was a lot of ambiguity, and they referred to the Advocate General's opinion that was more explicit on some things, but they referred to only parts of the Advocate General's opinion. So anyway, the court has picked the perception as the test. Do you perceive it as a mark? Interestingly, neither they nor the Advocate General never said we don't like reliance. The reliance was never rejected, right? What the Advocate General said was he didn't think that it was sufficient to recognize an associate. So the Advocate General clearly thought it's something more than recognize an associate. Whether he thinks it's reliance, he didn't say. The Court of Justice never said anything on either of them. It never said it's not reliance, and it never said it's not actually recognition or association. The way Arnold interpreted it, and he was quite candid, to be fair to him, he was completely candid about the fact that it was ambiguous. But he said he read that as not ruling out the possibility that he could look at whether there had been reliance. He said it's clearly not illegitimate. He didn't say I couldn't do it. And therefore, I'm going to take the lack of reliance into account in answering the question about perception. So perception is the test, but reliance is not irrelevant as a consideration in working out whether or not there is secondary meaning. All right. So when you go to the Court of Appeal, I've got a series of questions I'm going to ask you about the Court of Appeal, and then I'm going to ask you 3 hypos at the end to show where they're wrong in applying a slightly different set of facts. So first thing is just to parse a little bit more closely what they said about reliance, because if you read at least the popular papers and maybe even some blogs, I think there's a distortion of what the Court of Appeal said on that. What is the relevance of the survey? What is the relevance of limping mark? Both of issues that came up with the registrar. And actually, what is the real reason for the basis for sustaining a hearing officer? Because by the end you read Kitchen and Floyd's opinion of the Court of Appeal, I read them think they're going to reverse, and they don't. And I think the answer actually is they're just immensely deferential to the factual findings of the office. I'll come back to the EU IPO proceedings at the end, because the irony is that in the EU IPO proceedings at the moment going on, the EU IPO and the General Court and the Advocate General Court of Justice are proceeding on the basis that there is acquired distinctiveness in Britain, which is intriguing given that British courts have said there's no acquired distinctiveness in Britain. So they're clearly applying somewhat different tests as we go up. So the 2 opinions about Kitchen and Floyd, there's just a little bit of a different emphasis between the 2. I'd much prefer Lord Justice Floyd's, but I think they're not that far apart. So first thing is, Kitchen says this is an elusive distinction, he said, between perception, which is the court's test of when you have secondary meaning, and reckoning association. And no one other than trademark lawyers, he'd say, will possibly understand this. But it's an important one, all right? And then what he says is, consistent, I think, with Mr. Arnold, he affirms it, is that the test is going to be perception, but you can take reliance into account. However, why don't I focus on this sentence here? Perception by consumers that goods or services designated by the mark originate from a particular undertaking means they can rely upon the mark. And that's the word can, right? Not must. They can rely upon the mark or making or confirming their transactional decisions. In this context, reliance is a behavioral consequence of perception. It's quite an ethereal statement for a trademark opinion. So I got two points I want to make about this. One is actually, is that true? that reliance is a behavioral consequence of perception, if you can understand what it actually means in the first place. And secondly, there's a sentence preceding that, all right, which we'll go back to in a second, where he makes an assumption about confusion that I think underlies this sentence that I think is simply wrong. So what is the connection between reliance and perception? Well, I think this is true, which is if you've never perceived something to be a mark, you can't rely on it to be a mark. Right? So that, in that sense, he's quite right, in that the perception has to be an antecedent to reliance. The question is whether one can perceive something to be a mark, even if later on you decide not to rely on it. So if you think of the Coca-Cola bottle, for example, the Coca-Cola bottle, people probably perceive the shape to identify Coca-Cola. They probably perceive the figurative script. They probably perceive the red and white, and in fact, every one of those are registered as marks. Right? But do you rely on each and every one of those identifiers, every consumer, or even a sizable number of consumers? It depends whether, for example, how visually related you are, to the extent you rely on words, it's whether you're grabbing it quickly. You might rely on some of them in some contexts, and you might rely on them in others, right? And each one of those acts of reliance is dependent upon you previously having perceived. But the fact of reliance or non-reliance, I think, says very little about the antecedent question of whether you perceived it, right? And therefore, I think he has a problem, a necessary sufficient problem, in his particular reasoning, right? And if you read Annette Cour and Martin Senfenblin's treatise on European trademark law, they have a very little treatment of this, but this particular word can, I think, they pick up on, not with explaining the difference, they just sort of quote it, but I think it's a significant part, is that once you perceive that you can rely on it, you can use it as a mark, you might not, but you can, and that therefore tells you it is a source identifier, even if it's not always used. All right. A couple of other points that he makes that's worth. He basically endorses what Mr. Justice Arnold said, but I think he adds one little important wrinkle. He says reliance is not required. It's not necessary to show the public relied. So in fact, that is not the threshold. It's not as high as the question Arnold sort of suggested came from Light. He said, however, if you have relied, that's a sign that it is a mark. So what I think he's right on is if people actually clearly are relying on it, that is a good sign that they clearly must have perceived it, right? That's the antecedent question. But it's not necessary. And I think what I was just explaining is consistent with his articulation, that it's not necessary to have shown they've relied, but it probably is a very strong marker, if in fact they have. All right? And I think that those four passages, I think, sustain what I was saying about the relationship between reliance, between perception and reliance. Floyd, who I want to focus more on because I think he has a hypo that I think is really useful at the end, agrees the test is very settled, it's perception, and he, I think, makes an important point that when you're dealing with limping marks, so marks used in combination with other marks, the test here is going to be inevitably hypothetical. Right? You can't actually ask whether people relied on X in particular, because in fact they only see them in combination. Right? You have to construct a hypothetical environment, and so in fact surveys are going to be essential as ways of working out whether distinct parts of composite marks actually have proved the point that there is acquired distinctiveness. And when I was reading that, I kept thinking, he's going to disagree with Kitchen on this, because the survey, depending on which way you count them, is somewhere between 50 and 80%, which is a number that normally would get you home pretty quickly on acquired distinctiveness. He said, however, he didn't think the surveys were dispositive in this case, and the reason he didn't think the surveys were dispositive was because there was no other evidence that was in the record that would sustain a finding of acquired distinctiveness. So even though you weren't allowed to require past transactional behavior, i.e. you could not require, the registrar was not allowed to require actual reliance, and the fact that he purported to apply that as the test, despite that, Floyd is willing to sustain the registrar's conclusion because there was no other evidence other than the survey, and Floyd wanted some other evidence out there to be willing to say there was acquired distinctiveness. And it's interesting in terms of what that other evidence is, which actually Sir Geoffrey Voss in the third opinion agrees with him, was he wanted to see that it had been promoted, the shape had been promoted by Nestle as a trademark. And the reason why that's interesting is, you remember back to where I started with Arnold. Arnold said, the long-standing rule of European trademark law that whether or not something is a trademark does not depend on whether it's promoted as a trademark. All right? So there's a little bit of dodging going on, I think, between the different opinions. At the end of the day, a lot of it, I think, turns on the deference to the registrar's interpretation of the particular evidence. All right? All right, so where did they go wrong? I've got 2 or 3 points on this. I think the biggest problem is that the whole set of framing of the questions is nuts, which is whether consumers recognize, associate, perceive, identify, rely. These forms of reaction are degrees of semantic lines that it is simply silly to be focusing on, right? They're way too abstract for what actually goes on in the marketplace. Instead, the key is not the way you characterize as some sort of mental process their reaction. It's what is the content of the reaction? What are they having their recognition, association, perception, identification about? And you see that particularly from Floyd's hypo, which Voss agrees with is key to understanding what acquired distinctiveness is. So what I've highlighted for you there are 2 phrases of when something would have acquired distinctiveness and when something wouldn't. So he's using the word perception in both of these, right? So his line is not on perception versus something else. He's assuming this is all about what you perceive, not whether you perceive versus recognize, all right? He says if you perceive the goods as being Kit Kats, i.e. as opposed to some other chocolate product, then you have secondary meaning. If you perceive them that they look like Kit Kats because there's all these goods out there that have 4 fingers, then that's not secondary meaning, right? You're recognizing a descriptive characteristic of many, many goods, all right? So the content, what they should be focusing on is the content of what the consumers are looking at, rather than trying to give a semantic characterization. All right? And I think therefore the whole debate's been on the wrong part of the secondary meaning test, right, in that particular hypothetical. Why did they do that? And now I'll get to my 3 hypos to try and sort of prove that they're nuts. Is if you look at the lead-in to Kitchen's concerns, and indeed to the registrar's concerns, this sentence sort of stuck out, which is if you gave them protection, and then someone else uses a shape of another chocolate bar that's in their own wrapping, there would be no confusion. But I'm very worried, says the registrar, says Kitchen, and indeed you see this also in the Jacob Vignetta case. I'm very worried that because we have absolute protection, they will be able to stop the defendant from making what is a good competitive product where there is no confusion, right? So they're concerned about a double identity claim being brought that would essentially give a monopoly when it's not required because there's no consumer confusion, right? Now that's a genuine concern, right? That is interesting though. They're concerned about validity here. They're thinking about scope. If I give this trademark, what is the actual amount of protection? Now that I think is commendable, that part of it. The problem is they've sort of misunderstood the tools the Court of Justice has come up with to try and stop double identity cases being abused. So functional analysis, which those of you who found this might be heads bursting at the concept of going into more functional analysis, but it actually is a way of trying to restrict the scope of double identity claims to where there essentially is confusion, with the caveat that, of course, because of what we've done in non-origin functions, it gets messy in whether there could be an adverse effect on the other functions. But there are ways, and I've mentioned a couple here, but even within that, in dilution, you've got because, in double identity, you've got defining sign, you've got introducing context, you've got defenses that you could rely on to try and get out of jail, to preclude there to be immunity in instances where there would be no confusion. But you can see that that's actually a little bit of what's driving their concern, right? Is that there is a potential problem of protection without confusion. All right, so here's the hypo. His concern is that if consumers place no reliance on the shape of the goods at the stage of purchase, then no one's ever going to be confused by the defendant's use of the shape, right? And therefore, we'd be giving unjustified protection. So my question is that true? that if you don't actually rely on Nestle's shape of its goods in buying Nestle, even though you associate Kit Kat with that shape, that therefore you're never going to be confused when a defendant uses that shape, right? So I think that depends tremendously on what the defendant does, right? It depends on the scope question, it depends on the conduct of the defendant. Now, if you just said it's invalid, all these three defendants I'm going to put up on the screen get off scot-free, because there's no warrant for them to infringe, at least in the matter of registered trademark law. So the three I have, so rival A markets four-fingered chocolate biscuit in a opaque wrapper with its own trademark, like just say Cadbury's for sake of argument, prominently displayed on the exterior packaging, doesn't emphasize the shape in the rival. That's the hypo they're thinking about, right? So Cadbury's marketing their good exactly the same as Nestle. And I'm with them on that. I don't think that's infringement. It shouldn't be infringement. And there should be a way, I hope, within our infringement and scope and defenses doctrines to deal with that. And maybe we don't deal with the validity. But what if it be? Rival B sells four-fingered biscuits in transparent wrappers with no prominent distinguishing marks. All right, now, just because you haven't relied on the shape of the Kit Kat in buying the Kit Kat, which you know is a four-fingered, when it suddenly comes in the wrapper, and you associate that shape with Kit Kat, I think there's at least a serious problem that someone might be confused in that circumstance, all right? And that, if we have an invalid mark, there's no way as a matter of registered trademark law to stop that. This is a different circumstance from the first, right? The third one, just to make it a little more complicated, rival C uses opaque wrappers but has its own name, but it advertises the biscuits using the shape. That's important to recognize again that advertising use is use of a mark. Right? It is the type of use that is potentially infringing. This one, maybe it's a confusion case, maybe even it's an unfair advantage case under dilution. But it's a different case from the others. And if you resolve the whole question as a matter of validity, then in fact you don't have a way, as a matter of registered trademark law, to differentiate between those circumstances. All right? And so I would rather deal with these on scope, on defenses, rather than invalidating the mark and treating these three disparate circumstances exactly the same. And it's an example again of saying, okay, it can't be valid because in the plaintiff's context, claimant's context, you don't associate it, you don't rely on it. It's forgetting that there's other parts of the whole trademark picture that we should be thinking about in working through these particular problems. Now, you may say, well, there is an answer, right? And the answer is passing off, right? Now, if you want a fact-sensitive doctrinal vehicle, then passing off is it, right? It avoids the double identity problem because we don't have a double identity rule in those particular cases. The other problem with it is that the reliance test, which Arnold says in London Taxicab is definitely the law as a matter of passing off in England, has, as far as I can figure out, has only been successfully used once for the shape mark, and it's sort of acknowledged shape mark. It is the Henry the Hoover vacuum cleaner, in which Lord Justice, then Mr. Justice Floyd, found that Henry the Hoover vacuum cleaner was actually distinctive and had goodwill. Interestingly, he used a recognition test. You might not acknowledge that now, but he used a recognition test in that to find that it satisfied it. That's the only shape mark that I think succeeded since we adopted reliance test in the Hodgkinson case in the mid-1990s in the United States, United Kingdom. And the other problem, of course, is if you get passing off, it's a national remedy. So in the context of a European system, it strikes me as that's not necessarily a desirable result in this particular case. So passing off has some attractions. It's certainly more fact-sensitive, but it also has detractions as well. Now, where am I doing with time, Henning? That's about...
Well,
yeah.
5 to 10 minutes.
All right. So let me skip a little bit of the functionality stuff. Maybe just to a little bit at the end. Let's see. Oh, I can go through.
Well, you can have 5 extra if you want.
Yeah, yeah. I want to get the conceptual stuff. Yeah. So I'll skip a lot on the Hoke, but so from Hoke, just to put up the one screen thing. So remember on Hoke reverse. This is the screen, which is the pre-Hoke case law, right? Where basically the first indent of functionality basically had no purchase. You might as well forget it. And the third one, most of the case law went on the second. The third one had been, I think, potentially broadly interpreted in a couple of cases in particular where the court has said the fact that a design was iconic or had a branding appeal to it actually may make it likely to have substantial value. Hauk did a couple of important things. Let me see if I go to the bottom thing. I've never understood that as it looks like some sort of torture device rather than a children's chair, but it's in any event. So the
would be if you got into it.
yeah, I wouldn't try. Not without a bit of drink. Anyway, let's see. Hauk, you may recall, it sort of expanded the first indent by saying actually the fact that alternatives may not get you out of the first indent on functionality. And in fact, if the feature is the type of feature that a consumer would be looking for in the product, then in fact that might be functional as a matter of natural functionality. So what is natural is no longer a banana. It's something that the consumer would look for in a product of that type. So if they're looking for 2 legs on a chair or 4 legs on a chair, then that's a feature, natural feature of a chair, naturally occurring apparently, rather like a banana. So that was obviously a strange interpretation, but one that, to be fair, gives some meaning to the first indent. The third indent is absolutely almost impossible to fathom, because in 2 paragraphs like 31, 32 in Hauk, the biggest problem is that the court uses the referent it to refer to sometimes the shape, sometimes the good, sometimes the characteristic. And so therefore it's very hard to work out what the its are referring to in those 2 paragraphs, right? But there's at least 3 possible readings. So one is, so remember what they actually said was that this shape was attractive, that's the part I just can't understand, and it was reliable and comfortable and safe and all that kind of thing, right? So the question that the Dutch court had referred was whether or not the fact that it had all those other advantages in addition to being attractive was going to take it out of the third indent, right? So, but quite what the relationship was between those other things and attractiveness is not entirely clear in the court's judgment. So one reading might be, all right, the shape is attractive. The fact that the shape also, let me bring it up just to make it clear, the fact that that shape is attractive, the fact that it also is useful because you can move it up and down, for example, as the kid grows older, and it's safe because of the distances or what have you. The fact that that shape also has those other non-aesthetic advantages doesn't take it out of the substantial value. I think that's the most sensible reading of the language, was what that's saying. If we have a competitiveness problem because it's attractive, the fact that it does other things doesn't change that we have a competitiveness problem. It makes perfect sense. You might also read that, however, as saying, if the shape is attractive and has aesthetic value, but consumers buy it because of the comfort and reliability and safety, and that comes from, let's say, the fact that these are padded, i.e. not a feature of shape, a feature of texture. That doesn't take it out. Right? So you actually can have other non-shape features that give value, and that doesn't take you out of its substantial value. Right? The third reading which is the notion of what gives value has nothing to do other than minimally with aesthetics, which is that anything that adds value to it, whether it be aesthetic, reliability, comfort, or safety, is something that has substantial value. And the reason that last reading is potentially really significant is what it does is it basically throws the first 2 out the window. Everything becomes a matter of functionality under the third one, right? So this is interesting again because what this is doing is breaking down the formal barriers between the 3, and I think I'm sympathetic to this, to the idea that we should basically deal with all features of a mark and features of a product and assess whether protecting them and giving monopoly rights in them is going to have an effect inconsistent with the purpose of the trademark, right? Giving a monopoly effect beyond protection of reputation. And let's not get worried about whether it's a shape or another characteristic, in the Louboutin case, or whether or not it comes from the texture or something else, or whether something, the shape is 30% substantial or people are buying it 50% for the reliability. Those kind of questions which become mind-numbing shouldn't really be crucial to the sort of ultimate question. And a lot of the case law before Hauk, I think, is getting into that sort of like which pigeonhole do we fit it in, and therefore you have another flow chart to follow. So I'm sort of attracted to that within limits, a sort of open-ended, single, unitary approach to functionality. All right, so let me just skip to the last few questions. Allows me to skip Louboutin and the chocolate. All right, so couple of sort of priors. So I wrote a long time ago, and on a record, so I sort of have to defend it, but like time has moved on, maybe not that much, that I think, in fact, we are too miserly with our protection of non-traditional marks, particularly shape marks. And when I wrote that a long time ago, the argument I made was, in fact, in a global marketplace where language was becoming less significant, shapes and visual stimuli were becoming more significant, then in fact consumers were more likely to start using shapes and non-traditional marks rather than language. Now, that was sort of pre-internet, I wrote that, and the internet for a while sort of re-elevated language. I think, in fact, I'd fair to say that sort of Web 2.0, 3.0 probably switched it back away a bit off language, but we've become much more savvy with images than we were in Web 1.0. But that was the basic argument. One of the arguments against shape marks was that shape marks, there only were so many, they were finite, whereas words were infinite. Well, it's sort of interesting in some of the recent studies, though they would absolutely hate that I'd be using it for this purpose, knowing the two authors. But Beebe and Fromer have an interesting study showing that basically there is substantial congestion. Most of the word marks, at least in the US register, are already being used as marks, and there's not much space left. So one of the things the pressure is going to be on over the next few years is actually to create new marks. Now some of that will come out of new words, but some of it will actually involve composite marks that include non-traditional subject matter. And so in fact I think the case for being more protective than we are of product design marks, I think is still exists. To pick up on the passing off point, this is one aspect of the sort of broader conceptual lessons. In some respects, I'm attracted to passing some of this to passing off around for competition, in that it strikes me that there may be a role for features of levels of protection that are more tied to intent, which is historically, there's some aspects of our history where intent was more relevant in passing off, and where we may have more flexibility on remedies than we have in trademark. The problem is it hasn't really worked in the UK context, because that theoretical passing off case has really never been made. The other argument for using registration over passing off is that, and this was the main reason going back for why we had registration in 1875, was the ability to then engage in international trade by registering your mark in your home country and using Paris to get it in other countries. I don't think that's a huge argument in the global context, because Six Quinquas at Paris allows rejection on the basis of lack of acquired distinctiveness in the home market, so you're going to have to wait in any event probably to use Paris. But I think it is of some context, some relevance in the EU context, in that it would be good to have an EU solution to some of this. And so even the unfair competition, if you look at the Lego case, the unfair competition caveat in Lego saying you can copy a Lego, but you may have an unfair competition solution, again, gives the problem of lack of harmonization. This is probably the bigger point, so I'll probably try and finish on it, which is that I think the court has unhelpfully refused to look at one set of doctrines when it's thinking about others. So I've mentioned a couple of cases where this has happened, where they've said, we don't need to look at defenses when working out whether to give this, even though in fact, it seems to me, the fact you have a safety valve on defenses might inform whether you're comfortable in giving a right in the first place. And likewise, when you get to defenses in scope, the fact that something just got over the finishing line to get protected and a whole bunch of non-protectable stuff in there should be relevant to how careful you are in the way you delineate scope and the way you delineate relief. All right, I'm going to show you an American example of this in a second. And so I would like to see the EU and UK courts begin to be conscious about that, both in validity and scope. And if you buy that, it actually makes your definition concern, back to the purple case, more vital. Because if you actually have a set of protection that is tied more to the registration, then in fact you have to spend a bit of time working out what the actual definition is, and I'll show you the example in a minute. Importantly, scope is a normative exercise. Right? It's not just a question of the average consumer being a real-life person. The average consumer is a vehicle through which we vindicate a series of normative concerns, and therefore the fact that something has just gone over the line in validity, I think, should be potentially relevant. So let me skip to the example to show you, and I'll come back to the, so these are from the US cases. So the two cases of taking the distinctiveness inquiry into account in scope are Louboutin and a case called Giorgio O. So Louboutin is, this one you all know, this was been litigated in the EU as well, right? The Louboutin lacquered sole. So these are the actual shoes of Louboutin, and the ones in the US they were trying to stop with these ones, some of Yves Saint Laurent, which are monochrome, so they're all red, but the uppers are red as well. And so what the court eventually did was it said the mark consists of a lacquered red sole on footwear contrasting with a black upper, right? And the reason they said is that actually is what that mark is. It's not just a red sole. What actually makes that distinctive to consumers is the contrast between the black upper and the red sole. And then they said, all right, so if we define the mark as the contrast, that's not infringing. All right, so what they did was they gave Louboutin a valid mark in contrasting sole shoes to uppers. But they weren't going to get any protection beyond that. Why not? It's because they had all the concerns that made them really define this narrowly. They were concerned about competition. They said we're going to give this basically what we concept would be a thin mark, right? It happens not just in shape marks. So this is a case involving orange flavored vodka in the States where Giorgio got protection for this O, right? It's for orange, right? So it's an O, slightly elongated and orange colored, right? And Bacardi, you can see, has a slightly different, it's not quite as scorched, and it doesn't have this silver lining around inside it. What's interesting is the court said this was actually an unusual O. It said it was different from the normal O that was out there. They were willing to give them an O exactly in that, but they said this was not infringing, right? Because they said you have to use it identically. So this would allow Giorgio basically to stop counterfeits, right? But competition can go on. Counterfeit stop, counterfeiting go on, right? So there's an attempt to try and play with validity and scope as a way of solving it. And in fact, in the KP Permanent case, which I'll go back to the last slide I'm going to mention, in KP Permanent, which is a case about word marks in the United States Supreme Court, the Supreme Court said, look, if you pick a mark that is barely distinctive, in that case it was descriptive, that's the price you pay. Right? If you want to get a really broad scope of protection, pick excellent. Right? If you want to get something that protects the shape, protects something descriptive, that's the risk you pay in using one of those kind of marks. There's an awareness of the connection between validity and scope that is absolutely lacking, I think, in EU law. All right. Let me leave one last thing to show you. Just if I can find it. The other part is to show that there is hope in some of this. So this is the other part of it, of the different policy levers you use. One is validity, the other is scope, the other is defenses. And this is a awfully worded, but well-intentioned addition with the 2015 reform. So we added to the descriptive fair use defense something which on its face is illogical, which is that it shall be a defense to use a sign or indication which are not distinct, in which case, yeah, of course it is, because they can't be a mark if they're not distinctive, right? But what this was meant to do was when a mark that had minor distinctiveness got registration, you were still able to use the parts of that, and that's why I say you're better read as non-inherently distinctive parts of signs and indications that were that even though they were registered, were on themselves had some other function. And what's interesting about that particular, if I can get it, that particular defense is what they're trying to do, which trademark law, as marks become more complicated, needs to do more of. They're trying to separate out the protectable and unprotectable parts of a science. So there, even if you take something like, say, the shoe, there's parts of that shoe that have source identifying function, and then there's other parts of the sign that actually have other functions, and those are functions people should be able to copy if they're not source identifying. And separating of those functions is a hard task. It's an intellectually hard task. But we need the tools to do it. In fact, this defense, I think, actually is one of the ways that we might be able to do it. So I think there is some good news out there, but it requires, I think, the court of justice to do two things. Well, the British court the Court of Justice to do what? The British courts just need to understand that we are meant to protect shape marks. I just don't think they get that point. I remember until 1994 we didn't protect shape marks, and they've never liked that we protect shape marks. And I think any impulse to go way back to not protecting shape marks they have taken on the whole. Right? I think it's actually, and you can find in the Court of Justice that this reliance stuff, no one else in Europe thinks they're right. And you can find British decisions of the Court of Appeal saying it's recognition. Lord Justice Aldous, you can find decisions of the Court of Justice saying it's recognition of Phillips. The reliance stuff is made up in Britain, it's British made, and it is wrong. And I think that eventually, if we get a decision before we leave, we'll get something telling that. The British courts have to accept that shape marks should be protected if they're source identifying. But the Court of Justice and the British courts have to have a greater understanding of the interaction of the different pieces of the trademark puzzle. Right? So I got through a bunch of the slides, but not all of them, but I'll stop so actually we can have a discussion. All right?
All right.
So, questions?
Thanks a lot.